advocate for a client, but here's the thing. He put himself in a box when he said, my client's damaged.
You get a search warrant, you have to have probable cause that a crime's been committed and there's evidence in a particular place.
Hi, I'm Kayla Rowe from the Bianchi Law Group, and we're going to talk about terroristic threats today. But first, if you like what you see here on our video and you like the explanations we're giving, give us a follow below, follow us on YouTube, go to our website, book a consultation, or just give our office a call. We have more information, more experience, and more things of value to share with you if you do those things. So today we're talking about terroristic threats, and we're going to talk with former Morris County prosecutor Bob Bianchi and founder of the Bianchi Law Group. We're also talking to former major crimes prosecutor Dave Bruno, and we're talking to former Essex County Assistant Prosecutor Danielle Esposito today about terroristic threats. So terroristic threats, there's two main subsections about terroristic threats in the New Jersey Criminal Code. The first subsection is not really a predicate act for domestic violence. That deals with what you think of when you think of terrorism. We're going to be talking about terroristic threats under NJSA 2C12-3B, which addresses threats to kill. So this sounds a lot more like something that could be a predicate act for domestic violence, individual against individual. There are three elements to the threats to kill version of terroristic threats. First, there has to be the defendant threatening to kill a person. The threat for the second element has to be made with the purpose to put the person in imminent fear of harm. And finally, the threat was made under circumstances that a reasonable person would believe that they are in imminent fear of harm. So the first element is easy to talk about. Somebody says, I'm going to kill you. I'm going to murder you. Pretty easy on its face to take care of that first element. But the two other elements are a lot more difficult. And there's a reason for this. If those other elements aren't there to sort of be a protective barrier, you're going to see some infringement on the constitutional right of free speech. Accordingly, these elements are more difficult to reach in order to balance the protection of First Amendment rights with protecting people who are truly in danger of domestic violence. So with the second element, that the threat was made with the intention or with the purpose to put the person in fear of imminent harm. Like we've talked about in other videos, this is a difficult mens rea or mental status for the prosecutor to prove, because the prosecutor has to prove that the defendant had a purpose to place the person in fear. So if the person is just joking around saying, oh, I'm going to kill you, that doesn't qualify as a terroristic threat. Instead, the prosecutor is going to have to marshal other evidence to show what's going on in the defendant's head. That's not easy. And then the third element makes it even harder. That requires that the reasonable person would be in fear of imminent harm. That means that the person has to believe that, objectively speaking, an outsider looking in, a reasonable outsider would believe that the threat is credible, that it's going to happen and it's going to happen soon. Again, this is something that's very difficult for the prosecutor to prove, because what one person might subjectively be afraid of, the reasonable person might not be afraid of it and recognize it for the joke, the empty threat, whatever it is, it's not a terroristic threat under the 2C. So going to Bob. Bob, as the former Morris County prosecutor, tell us, what sort of proofs do prosecutors look for to prove these two tricky elements in terroristic threats?
Like you said, Caleb, one of the things that we do as prosecutors and as defense lawyers, we kind of reverse engineer it, is we're putting a plan together with our investigators and detective staff to find out whether or not we can prove the purpose. This is a very, very important part of what you just said, because people say things like this all the time, even when they're angry with one another, especially in a marriage that's breaking up. And not every single time a person says that I'm going to kill you, is that going to be a crime? So as a prosecutor, we want to make sure that we're targeting the right body of people, the right body of cases. And then the likelihood to be able to carry it out or not is another significant thing. If somebody's on the phone in a different country and says, I'm going to come over there and I'm going to kill you, that would not be immediate. So that would not be a terroristic threat. So what do I want to look for as a prosecutor? And alternatively, as a defense lawyer, what am I looking for as well? We're looking at electronic data. We're looking at the prior relationship. We're looking at all facts and information, and especially a deep debrief of what the victim is saying in the case, because we want to be able to give context to the statement that's being made, context that would lead a reasonable person to believe that this was a real threat, that the purpose was to threaten them, and that there was an opportunity, that is immediacy, that that threat could be carried out. Kayla, best example I could give you that. There's one thing in saying to somebody as you're breaking up, you know, I should kill you. It's another thing to pull a gun out, point it at them and say, I'm going to kill you. There's a difference between a non-crime and the terroristic threats crime.
Context matters, Bob. That's absolutely true. So turning to Dave as our former major crimes prosecutor, tell me how on this side, on the defense side, we reverse engineer these cases.
Yeah, sure. I mean, well, first of all, when we put this firm together, we made sure that we are only going to employ former prosecutors as our defense attorneys. Why? Because as former prosecutors, you learn the other side. You have the ultimate burden of proof beyond a reasonable doubt, and you have to put these cases together. So similarly, we employ former detectives as private investigators at this firm. Why? Because they know how to put cases together as prosecutors. And it really is the great equalizer for us, because the prosecutors, they have unlimited resources, really, police departments, prosecutors' offices. So that's one thing that we do. It's important to have the investigators run down things to really hold them to their burden of proof. And the other thing that we look to really is to attack the credibility of the witnesses. And in a case of terroristic threats, it's usually the alleged victim that's the witness there. And we see this in the domestic violence context. We see this in the criminal context. Credibility is everything. It's one of the things that the fact finder must assess and determine when evaluating whether or not a case has been proven by either the reasonable doubt standard in the criminal context or the preponderance standard in the domestic violence context. So we have found that, number one, former prosecutors are the best criminal defense attorneys because of their experience, as well as former detectives being private investigators that we employ at the Bianchi Law Group. Back to you.
Thanks, Dave. And speaking of credibility, you know, I'm just an appellate lawyer. I'm dealing with judges most of the time. I'm interested, Danielle, in your take as somebody who is a former trial prosecutor, who's been there, who's been in the middle of the action. Tell me, what are some real life examples of this immediacy element? And what are some real life examples of a situation where the threat is not immediate enough?
Thanks, Kayla. So some of the cases that I've seen come across my desk where I think that as a prosecutor, at least when I was on that side of things, I would get cases come across my desk that were terroristic threats that I often would know right away I might have trouble with the immediacy, because the immediacy is written into the statute. It's one of the elements, and there has to be a reasonable person has to believe that that threat is going to be carried out imminently. That statute calls for that element in there. And one of the things I notice is phone calls. Those are difficult cases to prove, especially if the individual does not live close to the victim when they are making that phone call. To call somebody, say, I'm going to come over, I'm going to hurt you, I'm going to kill you, and then threatening that individual. If they don't live anywhere near them, there really is no threat of that immediate carrying out of the harm. Now, it's different if they say, I'm getting into my car right now, I have a gun on me, and I'm going to come to the house and shoot you. There might be a little bit more play there with the immediacy, especially if the individual, and this goes back to the victim's, I guess, the defendant's state of mind and what the victim believes that the defendant might do. If the victim knows the defendant owns a gun, has a handgun accessible, and has had prior experiences, that might be a little bit more of an immediate threat to that victim, knowing that the defendant has the ability to have a handgun and can get in the car and drive there within a reasonable amount of time. But that's something that we notice a lot, or I've seen a lot come across my desk as a prosecutor, and as well as on this side is where the threats were made. Were they made face-to-face? Were they made via a phone call? It's also a lot different if somebody's standing in front of you with a weapon in hand, you know, threatening you at that point in time that they're going to kill you. Clearly, that's a little bit more immediate than a phone call might be. Thanks, Kayla.
That is some great information from the real world, Danielle. And if you're interested in this information and more real world experience from former prosecutors, Dave, tell our friends at home where they can learn more.
Thank you. If you like the video, give it a like, subscribe to our channel, the Bianchi Law Group YouTube channel. We are frequently putting out videos like this on substantive crimes, legal issues, developing legal issues, both in New Jersey and nationally. Bob Bianchi and I are both national legal analysts, and we appear regularly in the national media. We are a team of former prosecutors that aggressively fight the government when our clients are charged with crimes. We handle criminal defense, domestic violence, municipal court, and appeals. You could find us on our website, bianchilawgroup.com. You could find us on Twitter, Facebook, Instagram, Google+, LinkedIn, basically everywhere. We hope you found this content and the content in the description valuable, and we thank you for watching.